Court does call the case, People versus Jeremy Walter.
Absolutely, for the people.
Torshell Feaster, Assistant Public Defender. On behalf of Jeremy Walter, to the public podium, please stand.
Jeremy Walter.
Thank you, Judge. Thank you for giving Walter the opportunity to go to community corrections and to have his another sample given and tested. We did receive the results that sample was positive. I followed up and asked for the levels from the February 18th date to today, the 2/20 date, and those levels do appear to have gone up.
Skyrocket would probably be a word.
Well, yes, Judge, that would be accurate.
Okay.
My client, I spoke to him about the skin and asked him if there was anything he wanted to tell the court to clarify things. He's still adamant that he did not use any marijuana intentionally, and I informed him what was likely to happen, Your Honor.
Can I respond?
You may.
Thank you. What's of particular concern to the people in this case is that really the 218 test, the defendant was placed on bond, I want to say the middle of January, but I'll have it pulled up here in just a moment. And at the time that he initially went on 117, he said he didn't have the money. 127 he missed, 24 he missed, 214 he refuses, 218 we finally get a test and it's positive, and today 220 the test is increasingly positive. The reason that I'm particularly concerned in this case is because there are underlying mental health issues at play. The people do believe that we're at least in part responsible for the things that led to the charges. In my professional experience, the combination of THC with mental health challenges is difficult. I am very concerned about the defendant and his behavior while on bond, and I will leave any decision about the bond violation to the court's discretion.
Only thing I can say to his credit, Judge, that he did go test when we ordered him to. He come back. He did not flee, run. He's not sure how it's got in the system. He did have some housing insecurity. When he thought there might be some using at that location, he left that housing location to make sure he was not around any narcotics. He's not sure how this could have occurred, but he's obviously very apologetic that it's positive, and he understands the court's how the court treats these situations generally. I've made that very clear to him, but he says that he has not been using to his knowledge, Your Honor.
I'm not even sure what to say. I mean, as I'm looking at this, it's clear that first of all, we had a series where he's not testing. Then he's unable to test. Then he tests, it comes back positive. Then we're not necessarily dealing with it at that time. And then I get him here, and he's got an opportunity to tell me something's going on, and he's telling me it's all he's not sure, or some mistake on his part. And then I get the levels, and it's clear it's not a mistake.
Like I said, to Mr. Feaster here, that I was, because of my bond stipulations and the no contact order with my parents, which is where I was living before, I was living in a place that I realized was not safe, and I about 36 hours ago moved out of there because I realized that people were using there, and so I moved. I put everything in my car, and I moved to my to a place where I can be safe and be private and not be around people using. So I made a significant effort to remove myself from a situation that I realized was dangerous. So I am making significant efforts. It was not easy to move, to put all my belongings in my car, and to have faith that it was going to work out for me to stay in an office of a nonprofit that I volunteer at. But I made that significant change in order to remove myself from a potentially hazardous situation. So I'd just like to say that.
Only thing I'll add, Judge, is that my client was trying to retain counsel in this case. He's met with two different attorneys. I think he's planning to have one for his next court date. I'd ask the court for the soonest possible adjournment the court is able to give him so that he can hopefully see you again and have new counsel present for that next court date.
We adjourn to February 20th.
And this is the turning point. Once a judge believes the defendant is intentionally violating bond, the outcome is basically locked. Watch how fast the decision comes down. This time, given the positive test, I don't believe that the defendant...
27th, I'll set it to next week, 2025, 9 a.m., where his invite indicates. At this time, given the positive test, I don't believe that the defendant is telling me the truth at all, that he's intentionally violating the conditions of his bond. So for those reasons, I'm going to revoke the defendant's bond. Defendant is remanded.
Thank you very much, Judge.
Court calls case of People versus Campbell.
And is that on behalf of people?
Public Defender Buckovich on behalf of Mr. Campbell, who's now approaching.
Nelson Campbell.
All right. I set this date because the people had filed an emergency motion regarding the defendant's bond. We addressed it, was it Tuesday? I think it was. We addressed it on Tuesday, believing the defendant to be out of custody because he'd been released on a PR with a tether. As I'm to understand, he didn't get the tether. The tether had to be put on him prior to release. So actually, during that whole process, he was sitting in Washington jail. He had not been released. At that time, and I think we've not entered the bench warrant, certainly in the case, but I had increased his bond to $100,000 in each of the two cases that I had. Now I have three. So that's where we are.
Yes, Your Honor.
So you've had an opportunity to look at the people's motion regarding bond.
Yes, I had, Your Honor.
Have a response.
Yes, Your Honor. Addressing a bond, some facts about my client, he wanted to share that he is a student at Ypsilanti High School, currently working a full-time job at Comtech as a forklift operator. He's expecting his first child on February 28th, and he mentors youth throughout Ypsilanti. He denies the allegations of any improper contact with the complaining witness or any other party or committing any threatening behavior. He has a supportive family system, and he has a knowledge that in the past, in other cases, he has been successful on tether, so he is not a flight risk. So,
all right, response from the people.
Your Honor, in large part, we would rely on our motion. I just wanted to add a few new things and other things for these multitude of cases. This defendant is currently looking at a case for larceny of building, for trespassing, for a maluse, a case for aggravated stalking and maluse, a case for ammo possession by prohibited person, a case for another maluse against a different victim, another case of reauthorized domestic violence, and then there's one more case floating that we had to further get more information that will most likely be for an intimidation in relation to that dismissed reauthorized domestic violence case. He's been looking at a lot of different things, and I have extreme concerns about this defendant and his escalation in his behavior towards this victim. In this case, I didn't just put this in the motion, but the texts related to the aggravated stalking are extremely concerning. In his text, he says things like, "You've got one time to tell me who you're with before I start blowing. You're on some sneaky shit. I'm gonna start shooting. I'm gonna kill you personally for playing with me like this, or you want everyone to die. Do I have to call again or blow this bitch down? You're dying tonight. Answer the phone because now I'm killing you. And if you come out, I'm gonna wait for you. Now come out or I'm coming in forcefully." Among that, on his own personal YouTube channel as well as his Instagram, he has numerous pictures of him with different firearms that weren't recovered during the search warrant. Only over 200 rounds of ammo were recovered. I have extreme concerns that he would still be able to access firearms and carry out these threats against his victim, who is his ex-girlfriend. I have extreme concerns given that, especially with the new cases coming forward for this defendant. Beyond that, I know he has a previous adjudication for GBH in which he shot a different victim in the ankle, so this gives me even greater concern that he would carry out these threats against this victim. She lives in extreme fear. She's afraid to leave her apartment. due to the fear that he'd be waiting outside. She only leaves for school, and even then, she's extremely frightened to leave, fearing that he would be outside waiting for her in his car, that he would break into her apartment, things of that nature. I just have an extreme concern given the escalation, and that ammo was found in his house, and no guns were found or have been turned over to law enforcement, especially with him posting on social media holding different guns. I just have extreme concerns with all of these cases for her safety, as well as her friends or family who he also threatens in text.
Anything additional from the bench?
In relation to the guns in the YouTube videos, my client has acknowledged that they are fake prop weapons.
They are fake prop weapons?
Yes.
Then having said that, can you explain the 200 rounds in his house and where the weapons are that they belong to?
My granddad has owned the house for about 50 years and owned rifles, guns, and ammunition, but I did not know. He passed away in 2016, and I had no prior knowledge that anything was still left in my grandfather's house, sir.
I do believe in the police report, it states that some of the ammo was found next to his bed by his phone. And also, I was just informed previously on the DV case when it was authorized. This wasn't addressed then, the victim didn't show up for court, but he had been calling her from jail on that original case. That was never addressed. So I'm not sure what's exactly in those calls, but I have great concerns that he cannot follow court orders.
That's one of the cases.
And that'll be part of the case that's pending for the intimidation that we had to further and are waiting to authorize charges on.
Go ahead.
Yes, Your Honor. Yes, Your Honor. I understand that my client was waiting on another charge today as well. So at this time, he would like me to request that his PR bond be reinstated, or in the alternative, nominal cash bond, as he does have a cash bond in another case that he was waiting on this afternoon.
I think that was the domestic violence case. I believe it's 25,000 cash surety on that.
That is
On his DV case?
That was reauthorized, yes. And in these cases, we would be asking for the $150,000 surety bond.
Yeah. Well, in looking at it, the original bonds are set by the magistrate, and it's unclear to me that the magistrate knew everything that was as contained in the motion, but just given the escalation, as the people I think adequately point out, the defendant's behavior. Miss Weldon.
He's available. She's available. Let her know.
Yeah, let her know, because I think we stopped working in Ann Arbor at like 2. Us in the out county, we keep going till sundown. All right. And it's another day. I don't know why these judges trying to reach me. What did I do? Okay, hold on one moment. No, he's okay. Yeah, this is another judge. I know. All right. In regard to this case, there's certainly an escalation in his behavior. And again, I don't know what the magistrate knew. I do not believe what the defendant is saying, that there's 200 rounds of ammo, but that he has no knowledge of, and that all of these weapons are just props. And like, I don't believe that for one moment. I don't even know why you do that, but certainly the threats as against the alleged victim in this case are of grave concern to the court, and the defendant having the ability to carry those threats that he's making out. Court does believe that, first of all, with much regret, because again, I think I'm required to make this finding. I think that the original setting of the PR bonds.
These text messages, this is the kind of evidence that slams bond doors shut. When prosecutors read threats word for word, they're not just informing the judge, they're showcasing the level of danger.
And the other bonds in these 3 cases that are before me are an abuse of discretion, and the court is going to change those bonds. And I'm not saying that critically. I just think discretion was abused in setting them. There may have been information that the magistrate did not know. And I am going to therefore, I believe also then it poses a significant threat and risk to the community, and that the defendant would also pose a flight risk if released, but certainly poses a threat to the community, particularly the victim in this case. So in cases, I won't raise it or set them as high initially as the people are requesting, but in the case ending in 0179 and the case ending in 0193, I'm setting the defendant's bond in the amount of $100,000 cash as surety in each one of those cases. I will move the defendant's current, I'm moving them up to the 20th.
Understood.
Since I have increased his bond. I mean, yeah, I'm gonna leave them on the 27th. I don't know where I was. Thank you, Ann. That's right, because I was something by 5. And on the other case, I will set his bond, this being the case ending in 0192, also finding an abuse of discretion. I'm going to increase his bond in that case to a $50,000 cash surety bond.
The 0192, which case was that, Your Honor? I apologize.
Which one?
The 0192.
0192, actually, I don't, 0192 is larceny building.
Okay, thank you, Your Honor.
All right, thank you, folks.
Thank you.
E-printing. Okay, and then, I have all these files, I don't know. Let's call the case, People versus James. Is it Valkapur?
Yes, ready, Judge. Good morning, Your Honor. Marie Tanhoff, Assistant Prosecuting Attorney on behalf of the people.
And good morning, Your Honor. May it please this most honorable court, Nicole Casca. I am co-counsel with Scott Weinberg on behalf of Mr. Valkapur. Mr. Valkapur is in the jail. Can you please state your full name for the record? Nice and loud.
James Daniel Valkapur.
Okay. And you're requesting an adjournment?
Yes, Judge. It has come to our attention that after discussions with the detective on the case, that there is video discovery that's outstanding. I believe the people have not even seen it yet, nor do they have it in their possession. So we do need that in order to have discovery complete.
Your Honor, to clarify, I did speak to counsel this morning. There is video that normally would go out in our usual way through evidence.com. We suspect that there may have been some of the CSAM uploaded, hopefully not, but we want to make sure that's not the case. So I'm looking into that, and once I have confirmation that there's no CSAM part of that material, we'll make sure that counsel gets that discovered.
All right. Couple weeks or?
At least a couple of weeks. Please.
At least a couple of weeks. Is this the only thing holding him?
Yes.
I believe so, Your Honor.
Yes, Judge. He has no other contacts. He's not on probation or parole for anyone. He's got no criminal contact. His parents are in the audience. They've been here all morning since 9 o'clock.
Well, so have I.
Yes, you have, Judge.
Okay, so I don't know what that
Your Honor,
means.
may I, since we're talking about moving towards talking about bond.
Yes, go ahead.
Your Honor, I did receive the motion, I believe it was yesterday, so I haven't filed a written response, but if the court would like me to address it, I can.
Yes, you can.
Your Honor, I was at defendant's arraignment. This is a very concerning case. I will agree that there's no criminal history that we know of. However, I think as we all know, I don't think you escalate to this type of behavior just kind of overnight. To give some additional background that's not necessarily in all the paperwork, this is a matter where not only was there CSAM, and when I'm saying CSAM, we're talking about children involved as young as 18 to 24 months estimated on videos that are associated with this defendant, with his account. We're not claiming that he did the videos, but there are certainly adult males who are doing things to 18 to 24-month-old children that he apparently has an interest in viewing and stated in his account. In addition to the CSAM that was found, and I don't think it's necessary for me to go into the specifics of those, in addition to that, he's been in communication with an underage minor who is out of this country, not in this country,
That communication is not only of a romantic nature, if you want to call it that, but also of a sexual one. To the point where he sent nude pictures of himself to this minor, asked her to send nude pictures of herself, talked about masturbating to the thoughts of this minor. She reminds him that she is a minor, she's 13 years old, that this is not okay. She broke up with him, again, if you want to call it that, try to end all of this. He threatened to expose her, I'm not sure exactly what, but he mentions a selfie that he would expose. Make sure, essentially be submit to him completely, say certain things, do certain things, or he will expose her. She keeps asking him to stop. I think at some point there's talk about the legality of things. He says things to you sexually. He also says something to the effect of, I'm not going to get in trouble, and you don't have the balls to get me in trouble. Unfortunately for him, I do have balls to get him in trouble. That is not acceptable. We are not going to stand for that. I think the bond is more than appropriate in this case. I have grave concerns that not only was this CSAM, it escalated to these interactions with a minor who luckily was not physically in his presence. I have very little doubt that he would escalate to physical contact if he was given the opportunity to do so.
Yes, please.
Thank you. Judge, my client is 20. He is a junior at University of Michigan. He was doing extremely well. He was arrested, I believe, either on the 3rd of February or the 4th on campus in front of his fellow peers. Judge, with regards to those allegations, what was not relayed to the court is that this came from a tipster from the state of Minnesota who goes and gave this information about something happening on the same Discord. This is going on the Discord app, the same chat rooms. And the issue is that we do not have, I think the people are going to have some issues proving that, one, this person in Germany or wherever they are allegedly is in fact a real person and they're not, and that they are a minor. Second, we have, these are allegations. I know they're very serious allegations. My client understands that, so does his family. That being said, he is not a flight risk. We're asking the court, the bond is currently set at $250,000 cash. We're asking for something.
I'm trying to figure out if half of what the prosecutor's saying, why it's set so low, quite frankly. But you can go on.
Thank you, Judge. Judge, we are requesting a lower bond in this amount, 10%, so that family can post. They are here. They have no issues, and they do plan on going to court with him for all court dates, for any other evaluations or anything else that needs to be done on this case, making all appointments. He's not a flight risk. Judge, we're asking for something lower so that we can be able to go and get him out so that maybe he can, in fact, finish the semester that he has online with U of M. He has no prior criminal record, Judge, no juvenile adjudications, nothing of anything of this nature, anything assaultive, or allegations at the end of the day.
Well, yeah, but very serious ones.
Of course. And I know this court takes it very seriously, as do we. But we're also asking for justice to also be administered in a way so that Mr. Valkapour can have an opportunity to be able to defend against these charges with his counsel.
Anything else?
Here comes the most disturbing revelation. The moment the prosecutor brings up CSAM involving toddlers. This is where the tone of the entire case shifts from concerning to catastrophic.
Motion for bond reduction, I won't raise it. I'll leave it where it is. I'm not going to reduce it given the nature of the allegations as well as what I see here. So motion for bond reduction tonight is bond will continue. I'll adjourn the probable cause conference. I'll go out to the 6th and hopefully they can get all of that to you by that time.
Thank you.
March 6th, Judge?
Yes, March 6th, 9 a.m. So please.
Thank you, Judge.
Thank you.
Thank you, Mr. Valkapour.
Case People versus Cynthia Solomon.
Good morning, Your Honor. Mary Tan, Assistant Prosecutor.
Assistant Public Defender Jay Bellinger on behalf of Ms. Solomon, who approaches. Ms. Solomon.
Good name?
Cynthia Solomon.
All right.
Your Honor, we're here for PCC today.
No.
Okay.
No, go ahead.
Well, you know, it's my understanding that Ms. Solomon is working with our AIM division. For that reason, I'm going to be requesting a 2-week adjournment. I believe they're putting together mitigation for her and helping her with programming. But I would like to address bond. I think that's the more important issue of today.
Okay. Do you need a 2-week adjournment?
I do.
Any objection to that? Probable cause conference, February 27th, 2025, 9 a.m. Yes,
Thank you.
Mr. Bond.
As to bond, Your Honor, my client's in a family way. She's 30 weeks pregnant.
I understood what you're.
I figured.
Go ahead.
She is 30 weeks pregnant, Your Honor. She's very high risk. She was given a prescription before she started this pregnancy, and that prescription has not been given to her in the jail. She has no prenatal care while in the jail. She's already had an incident where she's had to go to the hospital once while in custody. I am asking for her release. She advises that she can stay with her fiance. No one involved in this matter. I believe the complaining witness is a minor child that she has no contact with currently. And she has no contact with her mother either. I'm asking that she be released as she is 30 weeks pregnant, going on 31, obviously, and she's...
So the child that is the subject in 1006 is not her child?
It is my child.
It is, Your Honor.
I'm mentioning it is her child. I believe the child is now with a different family member. And so that would be our biggest concern, is that make sure that there is no conflict.
You have it, okay.
Yeah. Well, who's the child with? Do we know?
My child's father, Your Honor.
That's our understanding, Your Honor, is that the child's with its father.
Was there anything else in the case?
No, Your Honor, I'll leave it to the court's discretion. I've been talking to Mr. Ballinger and one of his colleagues previously about resolving this case. Well, we want to see Ms. Solomon work on herself, and I think we can reach a resolution. I think she can be an excellent mother if she gets some things figured out.
I'm looking at. Without saying the names on the record, I have 3 names listed on her bond form of for no contact. Is one of those individuals?
All 3 of them. All 3 of them are, Your Honor. All 3 of my children.
So they're all 3 your children that are
Yes.
Your Honor, we had requested no contact with any minor. I don't know if that's going to be an issue, but that might be.
That will not be an issue.
Okay, for now.
That won't be an issue.
That will not be an issue, Your Honor. She advises that she can stay with her fiance. He lives in the city of Westland. She would not be in the vicinity of children.
Then let me ask this: is CPS currently involved?
Yes, Your Honor.
Okay.
I haven't had any contact with them since I've been in here, besides to discuss whether or not they were going to do a mandatory custody petition.
I know that they are working eventually on reunification, Your Honor, but at this time, she hasn't been. That doesn't, okay, all right, got it, all right. Since the no contacts are already in place and given what counsel's indicated, defense counsel's indicated for it. That's a call. Okay. I'm going to add a provision of no contact with any minor children. You understand that?
Yes, Your Honor.
I'll grant the reduction in bond. I'll set her bond. Thank you. I'll set her bond in the amount of $50,000 personal recognizance bond.
And Your Honor, if I may, my concern is that if she has the baby would be a minor child, obviously. Would she have permission to?
You are so bright.
It is a concern.
Your brilliance amazes me every week, Mr. Bellinger.
Just wanted to make sure that she'd be allowed to.
Okay, Mr. Bellinger, I hear you. Do you really think I would find a bond violation?
I don't, Your
Because
Honor.
he's in contact with,
I don't, Your Honor. But I just
oh,
want,
you're just gonna talk about it.
you never know. You never know with these prosecutors, Your Honor.
We're a bunch of troublemakers up here. We like to do our job.
Too well sometimes.
Wow.
Too well.
Wow. Boy, I know. Just, okay. Did you want me to make that exception?
Yes, Your Honor.
No, I'm not gonna make it an exception. It's not gonna be a bond violation.
Okay, thank you.
It's just not, I mean,
Thank you, Your Honor.
he almost blew it. I almost said, this is gonna get too complicated, so.
We got some overzealous people working here, Your Honor.
All right,
I do appreciate everything that you're doing, Your
No
Honor.
offense.
take care. Good luck to you.
You too, thank you.
All right. We'll be in touch, okay?
What did they have this?
You.
You.